Off the top, a federal judge ordered the Trump administration to bring back tens of thousands of federal workers who were fired from 6 different agencies, including the Department of Defense. The order comes as part of a lawsuit filed by labor unions, arguing that the Trump administration's mass firings of probationary employees violates the Administrative Procedures Act. That's a law that governs the hoops that agencies have to jump through to do a lot of things, including firing people. And late Thursday, a federal judge in Maryland ordered the Trump administration to reinstate the jobs of thousands of federal employees in 18 agencies by 1 p.m. tomorrow. The judge issued a temporary restraining order blocking the Trump team from continuing mass layoffs of these federal probationary workers. And this was part of a challenge that was brought by Maryland's Attorney General Anthony Brown and 19 other Democratic attorneys general. The states say that the Trump administration didn't give them enough notice, which is required when they fire more than 50 federal employees at one time. Maryland says that 813 former federal employees who lived in Maryland have applied for unemployment benefits since the day after Trump was inaugurated, and now they're coming in at a rate of 30 to 60 new claims per day. Birthright citizenship heads to the Supreme Court. We told you it would. On Thursday, the Trump administration made an emergency appeal to the Supreme Court, asking the justices to intervene in cases where federal judges have blocked him from ending birthright citizenship. So recall, Trump signed an executive order revoking what we call birthright citizenship. That just refers to a longstanding constitutional interpretation of the 14th Amendment that nearly all children born on American soil are American citizens, regardless of the citizenship of their parents. So Trump's order says anyone born to parents who are in the country illegally after February 19th, they're not entitled to American citizenship. 4 federal judges have blocked Trump from enforcing his executive order nationwide. And on Thursday, the Trump administration made an emergency appeal in 3 of those cases, asking the justices to limit what they call overlapping nationwide injunctions from applying nationwide to just applying to the parties before the court in each of the cases. And this is part of a broader criticism against federal judges who make these kinds of emergency decisions in one single case, but their order applies to everyone nationwide. Trump's acting Solicitor General Sarah Harris wrote, "Nationwide injunctions have not been good for the rule of law and risk the perception of the federal courts as an apolitical branch." As of this taping, the court had not yet called for a response from the challengers, but they would likely do so before weighing in. Earlier this week, the Supreme Court agreed to take up a case on conversion therapy. That's a technique that is used to try to convert someone's sexual orientation or gender identity. Colorado banned conversion therapy. So did Maryland and Virginia. But Colorado cited numerous studies citing that it is harmful to recipients. And Kaylee Childs is a practicing Christian in Colorado. She's a therapist who feels like she can't talk to her patients about accepting the body God has given them, and she wants the freedom to do that. So she filed a lawsuit challenging the ban, arguing that it violates her right to freedom of expression and the free exercise of religion. Now, it's too late for this term for the court to hear the case now. They'll likely hear the court case in the fall, with the decision to come by summer 2026. And even though this case comes out of Colorado, the court's decision will apply to these types of laws across the country, including the ones that have been passed right here in our region in Maryland and Virginia. Meanwhile, we're still waiting on whether the court will take up Maryland's ban on assault weapons. The court has been considering whether to take up a challenge to that ban at their conference for weeks now, but still no decision. Now to a different fight over the First Amendment. A federal judge blocked the Trump administration from deporting a man named Mahmoud Khalil, who was arrested inside a Columbia University campus room. Khalil was a grad student at Columbia until December, and he was told they were revoking his green card at the time he was arrested. Now, it's unclear exactly why Khalil was arrested as of right now, but it could be related to his on-campus pro-Palestinian protest activities after President Donald Trump and the Secretary of State Marco Rubio suggested a strong connection between the arrest and the protests, which are protected by the First Amendment. Trump promised that Khalil's is the first arrest of many to come, he said, saying we know there are more students at Columbia and other universities across the country who have engaged in pro-terrorist, anti-Semitic, anti-American activity, and the Trump administration will not tolerate it. Now, FIRE, we've had them on the show before. They're an organization dedicated to promoting free speech for all. They say that students are now worried about what this means for them on their campuses, and they've started reaching out to FIRE, asking questions.
The lack of information really promotes this chilling effect, which is a real problem under the First Amendment. When you have to wonder if what you say about either the United States government or even the government of a foreign country like Israel is going to land you in jail, we have a problem.
If the arrest is related to Khalil's speech, this could be a test case for how much tolerance the American people have for punishment based on exercising a core right protected by the Constitution. A federal judge in D.C. also blocked the Trump administration from going after a single law firm this week. That law firm represented Hillary Clinton during her 2016 presidential run. But the judge, when she did so, said it sends a chill down her spine. The order blocks lawyers from the firm Perkins Coie from entering any federal buildings and severs any government contracts with the firm. Judge Beryl Howell, an Obama appointee, said during the emergency hearing, such a circumstance threatens the very foundation of our legal system. Our justice system is based on the fundamental belief that justice works best when all parties have zealous advocates. That is, of course, referring to something that may sound familiar to you, right? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. You see it on TV shows all the time. Police officers reading suspects their Miranda rights, telling them everything the Constitution affords them at that point in the criminal process. Most crucially, the right to an attorney. And if you can't afford an attorney in America, guess what? One will be appointed for you, because we believe it is so important that everyone have an advocate in what can be a very complicated criminal justice system. It is foundational to our Constitution and our country. Just like the First Amendment guarantees you the right to freely practice your religion or express yourself, the Sixth Amendment guarantees you the right to counsel in a criminal case. The Trump administration's lawyer defended this executive order in court, saying that the president is allowed to do what he views as necessary to protect national security and eliminate any threat to the national security. They accuse the law firm of working with activist donors like George Soros to judicially overturn election laws, including voter ID laws. Switching gears now, 2 Montgomery County judges told the council's Public Safety Committee that they need more resources to ensure the safety of Montgomery County courthouse workers and all of the public servants who work in that system. They praised the sheriff's office for what they've been able to do so far, but they say it's an increasingly threatening environment to come to work.
This person appeared at an employee of the courthouse's home at 10 o'clock at night on a Sunday night, and this individual was staying at a parent's house. We don't know how this individual got that information.
Threatening, the blood of my children will be on your hands, and this doesn't end here. And it was repeated over and over and over again. My staff was concerned, my law clerk, my admin aide were very concerned for their own safety.
Dwyer told the council's Public Safety Committee that in her 28 years that she served as a state and federal prosecutor, not once did she feel unsafe or need to call for help. But that has changed now, not just for her, but for everyone who works in the courthouse. During his testimony, Bonifant listed multiple Montgomery County judges who are currently receiving threats. And both said more people are representing themselves now in court after the pandemic, and that they can get frustrated and things can get heated. Sheriff Max Wee is responsible for courthouse security. He says his office, like many police offices across the country, is down 20% of frontline deputies. He has to make some tough choices, he said, shifting resources from the domestic violence section, child support enforcement, and even midnight shifts to make ends meet. And this all comes as threats to judges are on the rise nationwide, particularly on social media. In fact, the U.S. Marshals recently warned federal judges about unusually high threat levels, according to Reuters. Meanwhile, Elon Musk and Trump advisors go after individual judges. We talked about it last week on this show. They're going after individual justices, too, on X, suggesting that these court orders should be ignored and that these judges are acting politically.
Everything you see nationally across the state, we see it here in Montgomery County. And I think generally folks, unfortunately, have been emboldened when they have the anonymity of social media.
Tim Sheridan, the court's administrator, says the family law section is seeing more cases, and that's where they can see these types of heated interactions. Also recall we told you about former George Mason University law professor Josh Wright, who had filed a $100 million lawsuit accusing two of his former students of defamation after they claimed he engaged in sexual misconduct. He apparently reached a settlement with the pair on the eve of trial, staving off what could have been a pretty tawdry affair in the Fairfax County Courthouse. Wright accused the former students of being scorned former lovers who lied about his conduct and hurt his reputation.